The court is in session in the case of State of Juristan versus Armahan Randawa. The prosecution, you may proceed.
To hear and determine the issues of law and the facts, or the authority by which their judicial powers take knowledge of facts and decide cases, or the authority to hear and decide the legal dispute, or the power to hear, determine the subject matter in the dispute among the parties, to assert and adjudicate or exercise any judicial power over them, or ability to hear, determine and declare judgment on issues before the court, or the power or authority which is given to a court by government to understand and learn cases between parties, and to give a judgment into the effect, or the power to inquire into the facts, to apply the law, to pronounce the judgment and put into execution. From here, the word we elaborated jurisdiction. Now I am coming to the fact that is the jurisdiction accordance to the law and the case. In accordance with the facts, the court of Juristan has a definite jurisdiction over this case because the offense is committed within the territorial jurisdiction of Juristan. Under the United Nations Convention on the Law of the Sea, Juristan has a sea area which is extendable to 360 nautical miles, which is based on the structure of the continental shelf of the state. So the crime is committed at 250 nautical miles. Yes, sir.
Offense कहाँ पे?
Offense from 250 nautical miles of the port of Zawadar. Yes, sir. सर यहाँ जो है फैक्ट्स में 8 में जो है सर 10 में जो है यस सर सर द नेक्स्ट डे देयर वाज स्टिल नो होप ऑफ द रेस्क्यू दे वर स्टिल stranded probably 250 nautical miles.
What does it mean by probably?
Almost sir.
क्या arithmetic figure के साथ degrees भी होते हैं? Probably approximation.
सर यहाँ जो है बात डिस्टेंस की है और डिस्टेंस जो है सर वो एग्जैक्ट हमें पता नहीं है. यस सर. सर लोकेशन डिस्टेंस जो है सर वो एग्जैक्ट पता नहीं है सर. यस सर. नहीं सर मैं इस चीज़ को जो है सर इस चीज़ पे वो इंसिस्ट कर रहा हूँ कि 250 नॉटिकल माइल्स हैं प्रोबेबली. वो इसलिए हैं क्योंकि सर जब शिप जो है वो रैक हुआ था वो डिस्ट्रैक्ट हुआ था सर. यस सर. यस सर. सर ये एस्टिमेट लगाया गया है सर. यस सर. सर ये स्टेटमेंट जो हैं जो केस के ऑफेंसेस जो है वो उसमें प्रोसिक्यूशन को दिए गए हैं सर. ये उस स्टेटमेंट से लिया गया है सर. यस सर. यस सर. ठीक है सर.
आपको प्लेस ऑफ ऑकरेंस पता नहीं है?
तो सर सी हैं. तो सर under the United Nations Convention on the Laws of the Sea, Juristan has a sea area which is extendable to 360 nautical miles, which is based on the structure of the continental shelf of the state. So the crime is committed at 250 nautical miles. Here we didn't mention probably or estimate. Here we mentioned the exact figure, that is 250 nautical miles. And the prosecution stands and rely and insist on 250 nautical miles. 360 nautical miles sir.
तो क्या जुरिस्तान ने यूएन क्लॉज को साइन किया हुआ है?
यस सर किया हुआ है सर. सर यूनाइटेड अकॉर्डिंग टू यूनाइटेड नेशन जो है लॉ ऑन सीज. हाँ लॉ ऑन सीज पे जो है सर उसको सर ये इसका प्रोबेबली पता नहीं सर. मैं प्रोसीड टू द नेक्स्ट क्वेश्चन. In next question, whether the killing of Dilrozain Qazalbash was murder considering the circumstances of this case or not. As per the facts and circumstances of the case, the killing of Dilrozain Qazalbash was completely a planned murder. It is evident from the facts that in the extreme circumstances of survival, stranded in the high sea without food and water for an extended period, there. Yes, sir.
अच्छा, आप कहते हैं कि ये मर्डर हुई है?
Yes, sir. It's a planned murder.
प्री-प्लान मर्डर है?
Yes, sir.
अच्छा, मेंसरिया है इसमें?
Yes, sir.
गिल्टी इंटेंशन है?
Yes, sir.
कैसे?
मेंसरिया ये है सर कि यहाँ जो है मिस्टर रंधावा ने जो है इस चीज़ को इंसिस्ट किया था रेस्ट ऑफ द मेंबर्स ऑफ हिज क्रू दैट वी शुड किल हिम. ठीक है सर.
देखिए,
यस सर.
killing बिल्कुल हुई है।
यस सर.
लेकिन यहाँ पे मेंसरिया क्या थी?
मेंसरिया ये है कि सर किलिंग मर्डर ही मेंसरिया है सर.
वजह के reasons,
वजह रीज़न ये है कि फूड की शॉर्टेज थी सर.
हाँ, necessity आती है।
यस सर.
मेंसरिया नहीं।
और सर इट इज़ टू बी कंसिडर्ड सर नेसेसिटी वाज लिमिटेड नॉट अनलिमिटेड सर. वो जो है इंस्टेड ऑफ मर्डर फिशिंग भी तो कर सकते थे सर. वो फिश को भी जो है वो कर सकते थे. अल्टरनेट वे भी जो है फाइंड आउट कर सकते थे सर. मर्डर वाज नॉट द ओनली रेमेडी टू सीक सर.
अगर फिशिंग हो सकती थी तो फिर वो मर्डर क्यों करते थे?
तो सर
क्योंकि फिशिंग नहीं थी, नेसेसिटी आ गई. But there is a well-settled principle of international law.
Yes, sir.
Necessity knows no law.
यस सर.
Fine?
यस.
जहाँ पर नेसेसिटी आ जाती है फॉर द टाइम भी हम वहाँ पे लॉ पे कॉम्प्रोमाइज कर लेते हैं.
Yes,
और
sir.
ये चीज़ पाकिस्तान में तो सबसे ज़्यादा हुआ है.
तो सर हम तो इंसिस्ट इस चीज़ पे कर रहे हैं कि यहाँ नेसेसिटी नहीं थी, यहाँ तो मर्डर है सर.
नेसेसिटी कैसे नहीं थी? 2 मंथ से उनको खाने को कुछ मिल नहीं रहे हैं. एक बंदा तो इनका वो कोमे में चला गया है.
ठीक है सर. कोमे में किस रीज़न की वजह से चला गया सर? वो शॉर्टेज ऑफ फूड की वजह से सर. वो शॉर्टेज ऑफ फूड की वजह से नहीं गया सर. तो बाकी क्यों नहीं गए कोमे में सर?
लेकिन he was weak. उसके एज फैक्टर पे depend-
He was young. He was unmarried. Rest of the crew members were married, sir. They should go into coma. Why they shouldn't get into coma? Yes, sir. As per the facts and circumstances of the case, the killing of Dilrozain Qazalbash was completely a planned murder. It is evident from the facts that in the extreme circumstances of survival, stranded in the high sea food or water for an extended period, they resorted to drinking each other's blood to sustain themselves. ठीक है sir. It clearly reveals that killing of Dilrozain Qazalbash was pre-planned by Armaghan Randhawa because he constantly encouraged the crew.
Have you heard anything?
Yes sir. Yes sir.
So don't
Don't you think that this, the very act which was committed, it falls in the category of Qatl Bayan? Have you gone through it?
Yes sir.
Have you given any thoughts?
Sir, it falls in the category of Qatl Ahmad, not Qatl Shibli Ahmad, sir.
So what are the main ingredients of Qatl and Shibli?
Sir, the main ingredients of Qatl Ahmad is, sir, they should act an offense. They should have an intention of that act, sir, while they are committing an offense.
have you gone through the facts? They are specifically stating that their intention was to just eat one part of the body.
Yes, sir.
So don't you think that it falls in Qatl Shibayam instead of Qatl?
Then why they have cutted their jugular vein instead of cutting a single part of his body?
So firstly, motive is the main ingredients
Yes, sir.
in an offense. So their motive was to eat just one part of a body.
Yeah.
So don't you think that it falls in Qatl Shibayam? Do you have any arguments?
Yes.
So, as legally speaking, we are lawyers, so we should argue it on point of law. Do you have any law or do you have any concrete legal point which indicates that it was Qatl Shibayam, Qatl not Shibayam? I am arguing that it might fall in the definition of Qatl Shibayam, not Qatl.
I strongly deny from your argument, sir.
So, on what point you are denying? You should state it legally.
I am insisting on this point that why they cutted the jugular vein of Mr. Qazalbash. the Rosen Kazalbash. Instead, they should cut their one part, their one single organ to feed themselves. Instead, they cut their jugular vein. It means they have the mensria. It means they have the intention to kill him. If they didn't have the intention to kill him, they should cut their one single organ, sir, to feed themselves. May I proceed, sir? Your Honor. Sir, for your kind for a kind consideration, sir, I would like to draw your consideration that in Katle Ahmad, the JPC section 300, it clearly states that when a person intends to cause death or bodily injury to another person, does an act which is ordinary course of nature is likely to cause death, or which is done with knowledge that his act is so immensely dangerous that it must in all probability cause death and causes death of such person, he should commit Katle Ahmad.
Mr. Yunus, what
Yes.
about the consent of Mr. Kazalbashi as already given to that?
Your Honor, Mr. Kazal.
Consent,
Yes.
if a person giving the consent in legal terms, where can it stand?
First,
Ultimately, he is ready to.
he denied. First, he has given his consent. Laterally, he denied from killing himself, from sacrificing himself. Laterally, the crew members drew a lot, and he instantly denied from that also, sir. And the next question is whether cannibalism is lawful under the theory of necessity or not. Cannibalism means the act of consuming the flesh or body parts of humans. It is totally illegally unlawful and against the dignity and the basic principles of humanity. It is not legal under the necessity of law. If cannibalism was the single choice to save themselves from the death, to save themselves from the hunger, they should choose an alternate remedy. They should try for fishing. They should send signals to the Zawadar port, and they should try for an alternate remedy. For that purpose, the single remedy is not cannibalism. And to conclude this point, cannibalism is not the only point and the option which has been left for them to save themselves. And now I would like to request my co-counsel to proceed the case. Sir, may I? Thank you, sir.
In your honor, with your kind permission, may I assist this honorable court? So as my co-motor described the fourth question, the fifth question, whether or not the principle of common intentions apply to Erosa Gil and others. The answer to this question is yes, and crystal clear that the principle of common intention apply here.
Your time is up.
So I request from this honorable court to for this one question is remaining, and okay, yes. Act is done by several persons in furtherance of common like common intention. When a criminal act is done by several persons in furtherance of common intention, to all of such person is liable for the act in the same manner and were done by him. It's stated in section 34 of Juris Penal Code. And then further, we argue on that whenever the common intention apply, why applies? She was presented, means Erosa Gil was presented in the ship, in the vessels at the time of occurrence of this criminal act. She was part of this crew while they draw a lot. Means there is means Riaz, actress Riaz as well this. She ate is meat. Means from the facts, there is stated in the 11th point, and the last para they says who cut off this meat.
Error number 10.
Yes. Yes.
Sorry, error number 9. 9, 1, 2, 4. However, Jerusalem rejected this option. यहाँ से आप read करें.
Yes. However, Ferozabel rejected this option and proposed an idea for the sake of survival that they should only cut one part of the body to get meat and eat. Its sense is already in coma, and it will only urge delusion subsequently not amounting to kill. With that, they all decide to sleep. Yes.
फिर भी आप कहते हैं कि यहाँ पर common intention exist करता है.
Yes.
वहाँ पर उसने कोई और चीज़ propose किया हुआ है, कोई और idea propose की हुई है, to the extent of inflicting harm.
No, my lord, whenever the cannibalism is openly discussed among the crew members, yes.
मेरा आपसे ये सिंपल सवाल है, यहाँ पर बिल्कुल क्लियर लिखा हुआ है कि जहाँ पर उनकी एग्रीमेंट हुई टू द एक्सटेंट ऑफ हाउट फ्रॉम द पार्ट ऑफ फेरोजाबिल नॉट किलिंग. क्या अभी भी आप इंसिस्ट करते हैं कि छोटी जो है वो इन्वोक करता है?
Yes. My lord, why I shall argue on this? Because the first, whenever the first occurrence, they, like Durzan Kazalbash offered himself for sacrifice, for the sake of the survival of others crew members. And he commented our argument that, Armagan Randawa is the great scientist, this and that. Then they denied. First portion is covered. The second portion. In the second portion, they, whenever they participated in like a lottery, like they draw lots, which is the custom of sea. So you are asking question from the first question, which is denied, and in the second question again in the second portion again they participated. So from the second portion I pick up that the Juris Penal Code section 34 is applied because they have common intention in the second. Yes. Oh no, I will. Yes.
Sir, time is already up, but one last question. What if we have to charge each and every crew member of the board? Can we charge it under section 34 or not? They are more than 5%, okay?
Yes. Basically, from the facts, they are 4%, not 5%, and one was killed.
Sir, I am saying, what if we had to charge all the members, all the crew members on board? They are more than 5%. Can we charge it then under section 34 or not?
Yes, sir. The question is in positive that they can charge under the section 34 all the members, except the exceptional cases Armagan Randawa, who is liable for 302. And once towards the prayer clause.
Thank you, sir. I think this is more than enough.
Okay, thank you.
Time is already up. Thank you, sir. Defense counsel, you may proceed.
Good afternoon, Your Excellencies. May it please the court. My name is Salim Javed, and I appear on behalf of the defendant, along with my co-counsel, Ms. Samira, and our legal researcher, Khalid Khan. I will be addressing this court on first two issues, and my co-counsel will address the rest of the issues. And I will take 7 minutes of the court's time. May I proceed for my first argumentation? Our first submission is that this court has no jurisdiction for some 3 reasons. Your Excellency, I would like to move your attention towards the page number 9, the second paragraph. May I proceed? In the event of a collision or any other incident of navigation concerning a ship on the high seas involving the penal or disciplinary responsibility of master or of any other person in the service of the ship, no penal or disciplinary proceedings may be instituted against such person except before the administrative authority, judicial or administrative authority, either of the flag state or of the state of which such person is a national. Your Excellency, the first point in this issue is the nationality. Dilrozen Kazalbash and Armagan Randawa are both nationals of the state of Nana. They are not nationals of the state of Juristan. According to the Article 9 of UN clause, the person who is national of another country is not subject to the legal proceedings within Juristan.
What about the amendment in the CRPC of 2004, who clearly says if a subject is involved in any kind of offense or in any kind of criminal activity, it can be treated as the person of Juristan.
Indeed, Your Excellency. Let me come to the point, that's my next point. But let me clear this point to you, that there was a contract between the federal government of Juristan and Mr. Dilruzan Kazalbash and Armagan Randhawa. The term or the time period for the contract was set for 1 year only, and it was already expired before the crime was committed. So in such situation, we can never say that Juristan has the jurisdiction to try the case in such concerns. May I come to the point? My next.
Raised another point. So if a person contract is expired, so can he kill anyone? Can he commit any offense?
No.
So you are implying you have categorically stated their contract with the federal government of Pakistan had already expired before the crime was committed. So if someone has committed any crime and they are not national of that state,
Indeed.
they are foreign national and they have a contract with that company, so they can commit any crime.
Indeed, Your Excellency. But my point is that the jurisdiction is related to the expiry of the contract. I'm not talking about the liabilities. That will my co-motor will explain such concerns from the next arguments, Your Honor. May I proceed? The next point is registration of the vessel. The vessel is registered in the state of, please,
यहाँ पर आपने बोला कि जो आप nationals of
state of Naina.
ये यहाँ पर कैसे मटेरियल भी कैसे अरेंज चाहिए आपको?
Sir, Your Excellency, it is available in the facts.
आपने इस चीज़ पे स्ट्रेस किया कि आप नेशनल ऑफ नाइना,
Yes.
आप इस चीज़ पे स्ट्रेस करना चाह रहे हैं कि नाइना की jurisdiction के ऊपर
Yes, Your Honor.
extend हो,
Yes.
लेकिन जुरिस्तान बिल कोड का सेक्शन कैटेगोरिकली क्या कहता है?
The jurisdiction of Juristan Penal Code extends in let me read it out. Extension of code to extraterritorial offences.
सेक्शन 2 of जुरिस्तान बिल कोड
The Council apologizes for being unaware of the fact at this time, Your Excellency.
अच्छा, यहाँ पर आपने कॉन्ट्रैक्ट की बात की कि कॉन्ट्रैक्ट एक्सपायर हो गई, यहाँ पर कॉन्ट्रैक्ट की एक्सपायरी या उसकी कंटिन्यूटी कैसे रहेगी?
The contract was already expired before the crime was committed, Your Excellency.
बिल्कुल हो चुकी है, उसके चंद दिन बाद ये ऑफेंस हो चुकी है।
Indeed.
कॉन्ट्रैक्ट का फोर्स होना और टर्मिनेट होना यहाँ पर रेगुलेट कैसे है?
It is based on the fact of the cases, Your Excellency.
इस केस में कैसे रेगुलेट है?
It is relevant in a way that the Juristan had the jurisdiction before the contract, before the termination of the contract. But once the contract,
अंडर दिस सेक्शन
it is, I'm not sure about the exact statute, Your Excellency.
यहाँ पर आपने मेमोरियल में एक पॉइंट 8 दी है कि रजिस्ट्रेशन ऑफ वेसल,
Yes.
क्या यहाँ पर वेसल्स की रजिस्ट्रेशन होती है या कंपनी की होती है? कौन सी कंपनी यहाँ पर कंसर्न है?
This is the only outline of that argument, Your Excellency. My point is that the registration of the vessel, it means that the vessel was registered in the state of Dilara, and it was not registered in Juristan. But according to the section 4,
नॉट वेसल वाज रजिस्टर्ड।
I'm generally talking about the provision, Your Excellency. But as per the section 4 of Juristan Penal Code, may I read it, please? The provision of this code apply also to any offense committed by any person on any ship registered in Juristan, wherever it may be. But wherever it may be, yes, Your Excellency. But as the ship registration was made in the state of Dilaram, not in Juristan, and the contract had already expired, in such a situation, the Juristan has no jurisdiction to try the case.
यहाँ पर ऑफेंस कहाँ पे कमिट हुई?
Offense was committed some 340 nautical miles away from the coastal state.
The second point, because this point is already has been decided in amendment 2004. It said whether the offence is committed within territory or beyond the territory. If it is in any term related with Jurisdiction, it is liable to be adjudicated by the courts of jurisdiction.
Indeed, Your Excellency. All right. The next issue in this case is whether the killing of Dilruz in Qazalbash was murder, considering circumstances of the cases or not. The killing of Dilruz in Qazalbash is doubtful. As per the section 26, which is reason to believe, Your Excellency, with your kind permission, may I read this?
Comments by the defendants. Sorry, issues.
All right, Your Excellency. It's a reason to believe that Dilruz in Qazalbash was a man of prudency. He had expertise in marine geology, oceanology, and international law. Being a man of such expertise, he knew the consequences of drinking the seawater. Once he has drank the seawater, he fell into coma. It means that he himself was willful for his death, or it may be called as a suicide, because according to the medical terminologies, sodium and water inside our cells need to be balanced with the sodium and water outside our cells. If the average human being can consume 9 grams of salt, but if he drinks the seawater, which contains some 35 grams of salt, in consumption of the seawater, our body needs a lot of water to excrete the salt from urine, which results in extreme dehydration. So it is really doubtful that he himself was willful for his death. The next point is that no penal offense exists against such offense. As per the Article 11 of the Universal Declaration of Human Rights, 1947, and Article 12 of the Constitution of Islamic Republic of Jurisdiction, 1973, these provisions declare or state about the retrospective punishment, that if there is no penal offense against any offense, then the person shall not be subjected to such offenses. The murder in this case is not an ordinary killing, where these people were subject to extreme necessity. Doctrine of necessity was is an important question in this case. So in such a situation, please.
यहाँ पर आपने mention किया order of sorry, this is the ठीक क्या जो theory of this is ठीक है, इसका scope इतना extend हो गया कि उस शीट में आप लोगों की जान नहीं ले सकते क्या ये political, judicial and administrative nature है?
Indeed, Your Excellency, but my point is that in such a situation, when
Purely administrative, judicial, political nature, administrative nature, इसके शीट में आप लोगों की जान नहीं लेंगे.
Indeed, Your Excellency, my point is that they were forced by nature, and they were under the doctrine, they committed the killing of Dilruz in Qazalbash under the doctrine of necessity. In such a situation, we can conclude that
हम ऐसा करेंगे जितने भी कमजोर लोग हैं हम उसको sacrifice कर दें.
no, Your Excellency, that is the other case. I have a case law, please. State of Queensland versus Eliza Nolan and Anor. The first page, Your Excellency. Judge Chester Man J. I declare.
Mr. I think you have got your time. You should give seconds. Charges we have short on time, sir.
All right. May I call for the next mooter, Your Excellency? May I go for the next mooter, Your Excellency?
Yeah.
Thank you.
Seconds speaker should come.
Assalamu alaikum. Hello. Assalamu alaikum. Good afternoon, Your Honor. This is Samira Haider. Your Honor, may I proceed with further argumentation? May I? Whether cannibalism is lawful under the theory of necessity or not. Your Honor, this answer can be very well explained by some Islamic principles, Your Honor. that the necessity removes restriction. It is an important Islamic principle, Your Honor, that it allows that under some compulsion and extraordinary situations, Your Honor, to do things which are otherwise, Your Honor, haram or haram, that can be considered prohibited. But in certain situations, they are permissible, Your Honor, under some Islamic principles. There are also some Islamic legal maxims that defend, Your Honor, this principle, such as harm must be eliminated. A greater harm is eliminated by tolerating a lesser one, and the smaller of two harm is chosen. Your Honor, in this case, a greater harm would be the situation where all the crew members are dying of hunger and thirst. And Qazalbash was already in a situation of coma, and the crew members were rescued after 4 to 5 days after the death of the chosen. Yes, sir.
You have talked about theory of necessity. Have you heard about natural theory of law? Can you go against nature?
Your Honor,
So, can killing a person, isn't it against nature?
Your Honor,
Necessity does not mean that you can kill any person in case of necessity.
yes, Your Honor, certainly we cannot kill someone, but the situations are supposed to be, Your Honor, considered. If we will talk, these things must be, Your Honor, sort of regard as legally justifiable in the eye of law, Your Honor, because if we will see towards this situation from a higher moral plateau, then, Your Honor, where the ordinary level of life is not working, then, and where the human limitations doesn't count, Your Honor, then we will take justice out of a context where ordinary life is not, standards are not met. We are we should not expect, Your Honor, some sort of heroic standards of behavior from Armaghan in this situation, but rather, Your Honor, standards of behavior of a reasonable person and a normal and ordinary person. So,
There's a situation, there's a circumstances that you are availing to the point of law of necessity. When it applies to all of the crew members, why to choose the weak and vulnerable?
yes, Your
Why
Honor.
the other three are not sacrificed?
Yes, Your Honor. Your Honor, because Qazalbash is already in a state of coma, and consequently, we can say that the, Your Honor, the value of the life of Qazalbash, who, regardless of the actions of Armaghan, is going to die sooner or later, scientifically speaking, within days, then the value of life of him is comparatively lesser than. Yes.
But I bring you on the point that our constitution says every life is equal.
Yes, Your Honor. Your
You can suggest that law of necessity give you the authority to take the life. Justify this point, please.
Yes, Your Honor. Constitution gives and secures the right of everyone's life and safety. But this situation, if we take it like one life is going to be ended, Your Honor, then it would make sense. But here, simultaneously, three other lives are also going to be ended, Your Honor. So I think this should be considered.
यहाँ पे आपने इस्लाम की बात की, रिलीजन की बात की,
Yes, Your Honor.
ऐसे केसेस जिसमें इंटरनेशनल लॉ कोड हो, वहाँ पे क्या रिलीजन का रेफरेंस हम दे सकते हैं?
Your Honor, the principle of necessity is something which is universal and applies to every human being around the world, if not principles of Islam, Your Honor.
यहाँ पे आपने मेंशन किया to avoid the greater harm,
Yes, Your Honor.
इसका रेफरेंस
To avoid the what sort of?
greater harm?
Yes, Your Honor.
थोड़ा सा मतलब
Yes, Your Honor. Yes, Your Honor. The legal maxims you're talking about, Your Honor.
रीजन बताओ, सेक्शन बताओ उसका,
Your Honor, they are Islamic principles.
इस्लामिक प्रिंसिपल
Islam-
ये हार्म भी या किलिंग भी मर्डर, तो हार्म की एक्सटेंट तक बात होती है ना,
Yes, Your Honor.
मर्डर
Your Honor, the principle can be analogized, Your Honor.
आपका टेक्सचुअल इंटरप्रिटेशन होना चाहिए.
Kindly complete your point.
Yes, Your Honor.
Consider your time, sir.
Your Honor, should I go with the prayer clause? Your Honor, furthermore, Wherefore, in the light of issued raised arguments advanced and the authorities cited, it is humbly prayed that this honorable court may be pleased to direct that the killing of Dilroz and Qazalbash was not murder but extreme necessity considering the circumstances of the case, in the charges under section 302 may not be framed against Armagan and others, and Armagan Randhawa is not liable for the offence of murder, Your Honor. And furthermore, it was a situation of extreme necessity, thus cannibalism is allowed in such a situation, and the honorable court may deem that principle of common intention doesn't apply to Arzugil and others, and pass any other order, direction or relief that it may deem fit in the interest of justice, fairness, equity and good conscience. Thank you very much.
The prosecution, you may proceed for rebuttal, and you have only 2 minutes.
May I proceed, Your Honorable Judges? Thank you. In rebuttal, the first question which arised and which has been highlighted from the opposite counsel, that is a case of nationality and non-resident. He mentioned that the accused were the residents of Naina, so it doesn't fall in the jurisdiction of.
Sorry to interrupt you. Leave the jurisdiction just to justify the necessity point, law of necessity. How a person in that situation, they said they are compelled to do it. Just to remember that point.
Ma'am,
Law of necessity.
on first question, sir, they talked about, sir, the non-residents of Naina. They said that the accused were the residents of Naina. They were not the residents of Juristan. If
That has been already settled. I told you that there is an amendment in CRPC in 2004 which already settled it down. Kindly come to the point of law of necessity.
Okay, ma'am. For rebuttal, I have the second question, that why the death of Qazalbash was doubtful. He said, as he mentioned in his arguments, that the death of Qazalbash was doubtful. It was not doubtful, it was clear cut, and the offenders were the Mr. Randhawa and Mr. Ferozabil. They both, with assistance, they both killed them. And
Also, your time is up.
sir, I need just 1 minute for third question, sir. May I?
You have 1 minute, please.
Thank you,
Just
ma'am.
conclude the point.
The third question which has been highlighted by the opposite counsel was that the consent was taken from Mr. Qazalbash. Instead, he was in coma. How his consent was taken from him? Thank you.
The defense counsel, you may proceed for survey.
May it please the court.
And we clear the point of common intention. All points are clear.
Your Excellency, the common intention and similar intention are two different principles. In this case, we may conclude that it was the similar intention but not the common intention. The elements, as there was no shared understanding and prearranged plan of the Armagan Randhawa and other crew members, they were not planning their stance to kill Dilroz and Qazalbash priorly. It was necessity and it was other circumstances whereby these people were forced by the nature to go for killing Dilroz and Qazalbash for their personal preservation, for the self-preservations. But it was not the common intention. Now proceed for next. The offense, according to the prosecution, the offense was committed in the territorial sea. This is why they have the jurisdiction. But the exclusive economic zone is only used for the economic purposes. It never means that they have the criminal jurisdiction in such cases where they are, or the court of Juristan has the competency to try the case. It is straightforward. The competent court, this honorable court, is not competent to try this case.
Counsel, your time is up.
Thank you, Your Excellency.
The court has adjourned for 2 minutes. Please all rise.